Sorry, I know it makes you upset.
Last class. Yeah. Last class. It flies by quicker every year for me. Roger, what are you dressed up for?
We have a little one.
Well, by you?
Negative.
Negative. Last class. So, no class on Thursday. Our review sessions was the 7th or the 8th. I'm sorry, the 6th. At noon, it's probably going to be in this room. I reserve this room. Might not be, but I reserve this room.
And noon, you said?
Noon, 12. At this point, if you want to meet with me, you have to send an email. I've met with all of you already at one point or other, but I will not be holding any regular office hours, but email me, I'll set up a time, okay? And again, the cutoff for any questions is the review session. After that, you guys are on your own. You're all by yourself? Or? Oh, that's good, right?
No,
I pay
Eric
attention.
Carmen.
Yeah. All right. Any other questions before we get started? Anything in your mind about a Burgerfell or anything else? I'm sorry?
Where's like that whole session?
I don't know. They're not here. John's all by himself. Sorry. Okay, I'm done. All right. Anything else? All right. I listen. It's bad. So our topic today is the First Amendment, and it kills me that I only have one class to teach it to you. It seems every year as the Supreme Court adds more stuff, I have to remove stuff. And unfortunately, this gets removed towards the very end. So you get a single class on the Free Speech Clause, the Free Exercise Clause, and the Establishment Clause. I encourage all of you as 2Ls to take a class in the First Amendment. I'm not teaching it, so you don't have to worry about me anymore, but I do encourage you all to take it soon enough. All right, so let's try this question. Let's see how this one goes. Sure, turn this thing off. A transition from last class to this class. This may actually work, maybe it won't, I don't know. All right, let's see what happens. The question is this. The government can prohibit speech that harms a person's dignity. This is the kind of question that keeps Anthony Kennedy up at night. He can't sleep over this one. He tosses and turns, thinks what's going for breakfast. It's a disaster. Okay. Where am I? Aaron, what do you think here, my friend?
Pardon?
What do you think?
I put true as evidence, I guess. Use Justice Breyer's concurrence and Snyder Phelps.
Concurrence, okay. And what did the concurring opinion say?
Well, I mean, he agrees that freedom of speech is protected in public spaces, but he also notes that the court has the power to restrict speech to protect individuals. And I guess that's where it comes into defamation laws.
Now, when you guys study defamation and torts, do you talk much about the First Amendment? Do you remember what you did back before defamation?
No, I was took it back. Well, I do remember defamation. I don't remember them trying to vaguely.
Well, what did you put here, Jay? While on you.
Actually, I'm just going to write it down, but I would say true. And I would rely on the case that was discussed, even though I wasn't in class last year, I still studied the case.
Obergefell.
case, and where he didn't really go. He kind of deviated from Justice Kennedy. Sorry, deviated from past rulings, and he said that dignity. There was a couple of elements that he used, and dignity was one of them. If it deprives a person of their dignity, and so that's something else. Dignity, autonomy, self-worth, and it's pretty by the 4th and 5th Amendment, that if the laws infringe on that, then it would kind of constitute the government not harming the person, those 3 elements. So I would say yes.
Okay, John, what do you think?
This is one of those that I feel like I would put E. If I
There's no E. There's only A and
Call
B.
me out on it later. When I think about defamation in particular, I think about actual malice, knowing falsity, and things of that nature. But I can't imagine that harming someone's dignity without some sort of pecuniary loss or something tangible along the way would fall outside the realm of the First Amendment.
Okay. So, let's think of it this way. All right, Lacey. If I go and I say to you something really hurtful, and I really hurt your feelings, the worst thing in the world, I won't say what it is, but I say something really terrible to you, can you sue me? I just say the worst thing in the world to you. I say something about your family, your loved ones, your whatever. It's really bad. Can I sue you?
Could you sue me?
I'm sorry, could you sue me? I
Oh,
say the worst thing in the world to you. It would make you really sad, make you really upset.
well, if I showed some kind of, that it actually harmed me.
Your harm is you were really upset. You didn't lose any business. I said to you one-on-one, there was no one else in the room, no one else heard it.
No.
Why not? Didn't you study in torts your favorite acronym, I-I-E-D? What is that? Do you remember?
Intentional infliction of emotional distress.
So, can you engage in I-I-E-D merely by words?
Yes.
You can. But I just asked you, Lacey, if I just say the worst thing in the world, I really make you emotionally distraught, right?
Right.
Can you sue me?
Yeah, you could sue me. I could sue you.
And then what's my defense going to be?
First Amendment.
Oh. So here's a dirty little secret about torts. Most torts that involve only speech are probably unconstitutional. The IIED tort, as we see in the Snyder case, which we read today, is on very shaky footing if it's only involving speech. Right? It is. The entire idea of privacy torts and the like is you're using the government, the courts, to stop someone from speaking at something you find offensive. Everyone understand that point, right? So there's a very strong tension between free speech and privacy torts, which you probably mentioned briefly. But I'm sure you studied libel defamation, right? So Rach, if I say to you, you robbed a bank yesterday. You robbed a bank yesterday, you should go to jail. Now, I know you didn't rob a bank yesterday. Can you sue me for that statement? I read it in a newspaper, top of my blog, right? Rachel robbed a bank yesterday.
Yeah, I could under libel, yeah.
Why? Because you made a false statement, right? Injured your reputation. Now, why can Rachel sue me for defamation or libel, but Lacey can't sue me for talking about something very harmful to her? Do you know the answer? Martin, you want to fix that?
Well, it'd be the difference of someone else hearing it or reading it.
Same, doesn't matter. I tell her one-on-one.
So you write it down one-on-one and just she sees it?
Yep.
I think that does change it, because then her reputation isn't damaged.
There's another difference, which you may not know. You don't know the difference I'm looking for? There's another difference.
Is it the element of knowledge?
It's not. It's not a torts answer. The answer.
Private versus public.
No. Yeah. That's not it.
Is it the effect on society itself?
So the Supreme Court has taken an approach to the First Amendment of saying certain categories are protected, and certain categories are not protected. It's completely random. So one of the categories of speech that's not protected is libel and defamation. Right? The Supreme Court has said that if you libel someone, that's not protected speech. It's not protected speech. But if you offend someone, like we'll have in the first case, the IIED, it may be protected by speech. So the answer to the question here is almost certainly false. I hope it's false. If it's true, then we're in trouble. But the reason why, let's go with the way the court has handled free speech cases. So here's the general umbrella, condensing the entire class into one lesson. If speech falls into a category that's not protected, such as libel or defamation, it's not protected at all. The court says we're just not going to protect certain categories of speech. Libel is one of them. If you're not in one of those categories, the court employs a test. And what's the test? If the government is restricting your speech based on its content, that is what you're saying, or a viewpoint, that is what your opinion is, you afford it strict scrutiny. Yes, strict scrutiny comes back.
Can you say that last part one?
I will be happy to, Adam.
The whole test.
So if speech falls into a certain category of being unprotected, such as libel or defamation, it's fine. Government can prohibit it. But if you're outside one of those few categories, and there are very few of them, you ask, is the government limiting speech based on its content or its viewpoint? In either case, you basically apply strict scrutiny. It's not that easy, but I'm going to summarize it for you for easy enough for one day of lesson. Which is why in the Snyder case, the family lost. Because what happened was he had a family that brought a claim under the tort of IIED. I mentioned Bob Dole in class earlier today, now I'm on IED. Yeah. I was talking about the Kilo case, and it was about Pfizer, so with the ED going. You had a case where the family brought the tort for IIED. And their basis was, we are bringing this suit because we found the content of the various signs offensive to us. All right? This the government cannot do. When the government starts picking and choosing speech on the basis of its content, then you go to strict scrutiny land. And as you know, generally, when you're in strict scrutiny land, the government uses even though this case didn't involve any law. Someone was trying to use Maryland's tort law to go after the Westboro Baptists. There is where the law intersects. We don't have many cases in this class where people are suing private parties, right? Almost all of our cases is someone sues the government or the government sues a person. This case, Snyder v. Phelps, doesn't involve either of that. It's a lawsuit by a private family suing this church. And because this law implicates the First Amendment, the court would not enforce it. We'll go through the facts in a minute, but I want you to get the high-level understanding. Okay? Adam.
So it sounds like the non-protected speech are categories that are subjective interpretations of what were said versus things that are, widely agreed as disparaging. Is that
Yeah, merely disparaging someone. If I call you a bad name right now, you might be mad at me, but I didn't violate your rights.
Yeah, what are five offenses?
Oh, okay. I can be mean. Not capable. Jaya.
I just wanted to understand the difference. Well, if this asking this under First Amendment, but it is under another, clause in the Constitution. I just don't understand what's the difference between, this speech and depriving one's dignity just by, saying something that's supposed to dignity that we've already established has not been actually defined in the Constitution. So how do you,
So let me ask you this question, Jay, right? Let's say a government official denies someone a marriage license to a same-sex
Right.
couple, right? We read last week, that denial deprives the person of their dignity.
right,
Now let's see, as the couple's walking down the street with their marriage license in hand, someone comes up and says, you know what? Gay marriage is a sin. Okay. Can the couple that just got that license earlier sue the guy in the street saying that gay marriage is a sin? It impacts her dignity in the exact same fashion that the denial of a license would. But can they sue for counseling gay marriage is a sin? That's a difference, right? For whatever reason, I tell you the reason, but for an important reason, speech is protected in our society at a very high level. And one thing you should notice about today's cases is that they're not 5-4s. Everyone knows that, right? How many cases have you read this semester which were like 8-0, 9-0, 8-1? Not many. This is the current court, the Roberts Court, is often called the most free speech protective court ever. Probably not true, but it's a court where basically all the justices tend to agree that free speech is important. And just this year, they've granted 6 free speech cases. I don't know what I'm going to do next year with the book. It's already published, but there were 6 free speech cases. There's a lot. Anyway, so I picked 2 for you to study for today. They're not by any means representative of the full extent, but they give you a pretty good sampling. So we have Snyder v. Phelps and also Matal v. Tam. Did any of you see the slants last year when they came to Houston? Okay, very good. So you saw Simon, right? It was annoying because, of course, they're a rock band. Their bus broke down in Dallas, and they couldn't come play a concert. They were supposed to put on a show, but it didn't happen. Okay, so let's do Snyder first. Jessica, yes, back up top. All right, last time around the room. I think so. All right, can you give us the fact in Snyder?
So the Snyder family sued the Westboro Baptist Church when they visited Matthew Snyder's funeral.
Good.
Basically on a bunch of work claims that ended up
Okay.
and they were originally,
Where were they actually protesting? Were they protesting in the cemetery?
no, they were protesting across the street on public.
Did the did the Snyder family actually see the protest the day of?
No,
No. When did they learn about it?
that night.
How? News. Very good. So the facts of this case are often grossly misrepresented, which is why I poked Jessica on that point. So this is Matthew Snyder, who was killed in Iraq in 2006. The Westboro Baptists are a group, church, if you will, that holds beliefs that America is in decline because of sin. And one of the cardinal sins in their mind is homosexuality. And the way that they have decided to spread their message is by going to cemeteries and funerals to protest service members, celebrities, basically anyone that they deem sinful. They protest their funeral. Guys at their college campus, the A&M, where they come to? Yeah, where they go into Baylor? Yeah. Were there any incidents when they came to your school?
Yeah, people were like kicking signs and stuff.
Yeah, Amber?
Yeah, I mean, I went to Sam, but.
They came to Sam Houston?
They came to Sam, and, I mean, I couldn't walk down the main mall area without them screaming things at me. So.
Yeah. So they get around, and it's basically a couple families. It's not a large church, but they have money from not exactly sure where, and they engage in these messages throughout the country. I've never seen the Westboro Baptist in person. I did see pictures of various signs. Yeah. I did see, where is it? Yeah, I did see these guys. I was at the Supreme Court back in, this is 2009 or 10, the night before oral arguments in the Snyder v. Phelps, and this was just, a random family standing outside the church. I'm sorry, the Supreme Court. I want to play a brief clip. This is the guy. I'll just play a minute of it. Come on.
This is your interview?
I'm actually staying outside the United States Supreme Court on the evening before arguments in Snyder v. Phelps, and I'm with Orlando. Orlando, when you're wearing a shirt that God hates Muslims, why are you wearing that shirt?
I'm wearing the shirt because it's a biblical truth. The way, the truth, and the life, and no man cometh unto the Father but by him. Any other belief system that excludes Jesus Christ as the way to heaven and the way to God is an abomination in the sight of God. Because God has already sent his only begotten Son into this earth realm.
Okay, you get the idea. But what I was struck by was it wasn't just this guy with his T-shirt, which looked me with a magic marker like an hour beforehand. He was there with his son and his daughter, and they were sitting there all night by the Supreme Court, right by the right on First Street. And I talked to the guy for a few minutes, like, why are you doing this? And why are you wearing that shirt? And he was very honest and very candid. He didn't lie. He said, "I'm trying to convey a message that if you don't believe in Jesus, you are going to hell, and God hates you." Okay, so that's a message I'm sure most people in this room probably don't agree with, but is it a message worthy of protection? Right? And that's really the question the court addresses, right? Chief Justice Roberts wrote the majority opinion, doesn't come out and say, you know what, I agree with Phelps, right? I agree with these people who hold up these signs, right? Roberts is not saying that. Instead, he makes a different point. That as a society, we should speech even that which we disagree with. Now, we always hear, I respect your right to say something even if I don't agree with it, right? But I want to pause on this point for a moment. Why do we protect such awful speech? Look at these signs, right? Angela, why do we, and this is a 8-1 opinion, this wasn't a 5-4. Why do we protect such awful speech that is no doubt harmful and impacts people's dignity? It's just as Kennedy's favorite word. Why do we protect this sort of speech?
Well, one person finds offensive, somebody else might find non-offensive. So it's unlikely that anything that somebody says that everybody will find that to be not offensive.
But wouldn't you say that someone who finds this message acceptable is messed up and wrong, perhaps?
Well, I would, but there are other people out there who say they won't look at it not. It is not something they would probably, they would think it is.
But why are we only thinking about the person who's, a bit loosey-goosey? Why do we think about the people standing next to him and telling them that God hates you and you're going to hell and you're an awful human being? Why do we protect speech at these sorts of messages? These signs?
Because it's like a slippery slope. That situation where you start restricting crazy speech and then you start restricting less crazy speech and you start restricting speech, whatever you disagree with.
So, is there no limit then on how offensive a sign you can put up at a guy's funeral?
I mean, no, I don't think obviously there's not a limit because, I mean, that's just about the worst thing.
Yeah, you can't get much worse than that,
yeah.
can you? Okay. Elizabeth? Actually, your hand up?
Well, I was just gonna say the limit is based on like whether or not you're calling out someone specific. Like if they were to say the Snyder son.
Oh, okay. So what if the sign said, "Thank God that the IED killed Matthew Snyder"?
Well, they cannot. That's not protected because it's not a public concern. They're using all language that is military related or.
So actually, I'm sorry, Elizabeth. Let me go back up top. Is this speech about Matthew Snyder? about?
It's about a public issue and
What are those public issues?
it's just morality in our country.
Yeah, gay rights. Yeah, I mean, morality is basically, what they're saying is the decision to have gay people in the military and otherwise has resulted in this sinfulness. What if, someone held up this sign as an anti-war protester, said, "Thank God for crippled soldiers." And the exact same sign was held up as an anti-war protest. I mean, I don't think anyone was alive back in the 70s here, but when you had guys come back from Vietnam, they'd be spit on. How old were you, Mark, in the 70s?
I was born at the end of November in '79.
Okay, so you weren't there. You were not there for Vietnam. That's okay.
I snuck in.
You snuck in. You're not a millennial. God bless you. You're the only non-millennial in this classroom.
I think Garner's with
What's the year report? 76? Okay, you were a non-millennial either. But the point is, there was a time when soldiers were basically spit on and were scoffed at, right? You don't see that too much anymore. But if you held the exact same sign saying, "Thank God for crippled soldiers," would that be okay if you're protesting a war? So what I think we're getting at here, if I can synthesize a bit the discussion here, it's dangerous to start letting the government censor speech. Even something you find absolutely awful because of a slippery slope issue. Andre mentioned, I think that's right. Daniel also mentioned who's the arbiter to decide where you draw that line. So for better or worse, the court is on point that you can't punish speech merely because of its content. That's not the rule in other countries in the world. In most European nations, you can punish someone for offensive speech. You can do it. You can throw people in jail for racist speech and what they call hate speech. We don't have in this country a notion of hate speech. It's just not a thing. You have hate crimes, which are certain acts of violence with a certain mens rea attached to it. That can be punished. What often happens is a certain crime becomes a hate crime with a certain intent, and you enhance the sentence. But hate speech is not a concept we have in this country. In no small part to decisions like this. Emily?
Trying to wrap my mind around what you said. You can't punish speech merely because of its content. Does that imply that speech is more than just words?
Speech can be written, put in a sign, you can sing.
But I mean, like, does that include action?
Like what?
Refusing to bake a cake for.
Well, that's speech the other way, but I think the example you think of is a cross burning, perhaps.
Sure.
Right? Well, the cake case, which I'll get to a little bit later, is can you make someone engage in a speech act? That's a separate question. But what if it's a speech act? For example, burning a cross, right? Or hanging a noose. Right? So with those cases, okay, let me give another example. Zach, what if I tell you, Zach, I'm going to kill you tomorrow? That's my message. I'm going to kill you. Can you call the cops and have me arrested? Let's say I'm serious. I'm not going to kill you tomorrow. I might be here tomorrow, right? But let's say, Zach, I'm going to kill you tomorrow. Can you call the cops on me?
Probably not.
Probably not.
I mean, you can, but they're not going to do anything.
It's not imminent harm.
I don't care if it's imminent. If I say, Zach, I'm going to kill you tomorrow, is there no crime? Did you say criminal law? What's the crime there?
Words aren't the same.
Yeah.
Threat. You can't threaten someone. You can't threaten someone. No, you can't. Right? You can arrest someone for threats. Right? If I say I'm going to kill you, and I'm damn serious about it, I can be arrested for threat. Now the question is, you can, trust me on this one. How can you arrest one merely for words? One of the categories of unprotected speech is threats, right? You can't threaten someone. So certain types of acts with a certain intent behind it, for example, I'm saying it with an intent to harm you, right? That is not protected. If I burn a cross with the intent to intimidate someone, that's not protected either. So you can have what are effectively speech acts, depending on the intent, can be punished. But merely saying something that's offensive, a racial slur or anything of that nature, that cannot be punished.
But if you burn a cross because you're burning a cross because you felt like burning a cross without the intimidation issue, that's okay.
So there was a case, which again, I'm summarizing the entire body in one day, but there was a case of RAV versus St. Paul, which was a case from Minnesota, where we basically had a teenager, I think it was 17 or 16 years old, who just burned a cross because he was an idiot. He actually didn't have the intent proven. He was trying to intimidate someone. And the court reversed his conviction. Right? There was another case some 20 years later from Virginia, Virginia versus Black, and the court there upheld the cross-burning condition because the person had the intent to intimidate. So the intent actually matters. This is where torts and criminal law actually merge into ConLaw as well. The intent is actually very important in those cases. But the general rule, though, is merely saying something offensive in the U.S. is not a crime. You can't be punished for merely saying something offensive. And that's the holding in Snyder.
But if it's like a private corporation or private business, they can regulate that. Am I understanding that correctly? Or
I think I know what you're asking, but give me more.
like with the NFL.
I know that's what you're asking, yeah. That's right there. Yeah.
With them taking a knee.
Yeah, so when the First Amendment only applies to corporation. I'm sorry, to government speech, right? A private corporation can regulate their employees however they want, whether they're athletes, whatever else. So yeah, you must stand for the pledge or the national anthem. They can make them do that. There's not any First Amendment issue there.
How much do private organizations have?
A lot. So I'm putting aside any labor issues because sometimes unions can negotiate contracts for employees if they have protection for speech outside. But generally, in most states, we have what's called at-will employment, which means a boss can fire a worker for anything they want, speech or otherwise. It's a little bit different for government employees, because government employees do have First Amendment rights, but they're limited. Okay, Ashley?
What about institutions that are like a school that's like, we're private, but we accept public funds?
There are restrictions on this school's ability to censor your speech. That's absolutely true. State schools as well, but yeah, South Texas is not bound by the First Amendment, but we do try to adhere to it. At least I make sure people do. My livelihood depends on it. So let me again. I'm not too concerned about the specifics of the tort case, but the opinion by Chief Justice Roberts explains that this is speech on matters of public concern. They're effectively glorified anti-war protesters with very awful messages. They're talking about moral issues in America, and these are of general concern. The signs, as someone noted, do not mention Matthew Snyder. And more importantly, the protest didn't actually happen in the cemetery. It happened across the street, and they didn't learn about it until much later. So a decision of the court striking this down would be very serious, because you're basically saying people came and protest a funeral across the street where they're out of sight, but not out of mind. Okay. I like the Chief's. By the way, you don't read many Roberts opinions, but he's such a good writer. I love this one. He writes, "Speech is powerful. It can stir people to action, move them to joy and sorrow, and, as it did here, inflict great pain. On the facts before us, we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech on public issues, to ensure that we do not stifle public debate. That choice requires that we shield Westboro from tort liability for its picketing in this case. So in effect, the court won't even let Maryland's tort of IIED go into effect." Aaron?
So if they had specifically mentioned Snyder in the signs of the protest, would it be protected?
So this is where I think the majority goes a little bit off the rails. Alito's Dissent talks about this epic. Everyone see that? The edit in your case book is not very good. The third edition will be better, as I always say. there wasn't just the signs at the funeral. There was also was basically a blog post, but they called it an epic. And this was put on the Westboro Baptist blog. And the epic named the parents, Albert and Julie, of Matthew Snyder. And they wrote that Albert and Julie ripped that body and taught Matthew to defy his creator and to commit adultery. They taught him to support the largest pedophile machine in the world, the Catholic Church. Catholic monstrosity, as they call it. The majority noted in a footnote, which I don't think was in your book, but it was in the opinion, that they won't consider the epic because it wasn't mentioned in the cert petition, which was garbage. That was part of the case. Alito said, based on the cert petition, based on the epic, you could actually make a case of IED. If you can include the epic, the case is a lot closer, because you're actually mentioning it by name. Although my sense is I think the Phelps would still win, because you're basically saying something really mean about someone on a blog on a matter of public concern. I don't think the court would even go for liability there. But they avoid the issue by saying we're not going to consider it. So in the end, after all this litigation, this poor family got 0. And had to pay attorney's fees. Andre?
I feel like they are expert protesters.
Oh, they're good. You're right.
They know exactly when they're within their rights.
Now, Amber and Zach, did you hear them speaking anything, or were they just standing there quietly with their signs? Do you remember?
Yeah, they were yelling at people. Like,
Oh, yeah.
if a girl walked by in like a tight outfit, they would be calling her like whore and stuff.
Yeah.
So, go ahead.
Is there just one group?
There are a lot of them. I mean, there's one group, but there's like 20 or 30 of them. And they come there with their kids also.
Yeah, it was mostly families.
So the other wrinkle here is that when they were at the funeral by the Maryland thing, they were silent. So Andre, I think, is right. They were expert protesters. They only did for a couple minutes, and they were there silent. And in fact, if I remember correctly, the government put like a little quadrant where they could protest to protect them from the outsiders, right? So basically the police were protecting them. And they were only there for a couple minutes. They do this just to get attention. Yeah, Elizabeth?
Just on his point, he was saying they were experts. I listened to this podcast and this lady who used to be in the church.
Yeah.
She was on it, and their whole family is actually all lawyers.
They
so
are.
That's how they have enough money and how they're so smart about this protests.
Well, they're not that smart. So the case was argued by Margie Phelps, who's Fred Phelps' daughter. She wasn't very good. She was better than the Harris County DA, Harvey Lawrence. I'll give her that much, which is not a high bar. But she wasn't that good. Damn. I saw another hand somewhere. Just put your hand up. All right. So other questions on Snyder. Very tough case. I mean, again, imagine a case like this, 8-1 in favor of the Westboro Baptist. I mean, that's significant. Only Alito dissented. I think he was restrained in his dissent. All right, who's next? Anthony, I think you're next?
Yep.
All right, let's talk about the slants. You can't get further from the Westboro Baptist to the slants. I mean, it's like opposite worlds. These guys like crunchy Portland, like social justice warriors. Completely different deal. Yeah, Andre.
One more question on
Yeah.
dissent.
Yeah.
Do you think that Alito dissented just to give a voice to the Snyders?
I think so. I think that's a very astute observation. I think he did. Alito has a very strong connection to the military. He does like wounded warrior stuff. I think he was just incensed by this case. So I think he wrote dissent alone would be 9-0. But yeah, it was just him. Yeah, Kevin.
And his faith, most likely, because they were attacking the Catholic Church as well.
I wouldn't go there. I think it's very dangerous when you say a justice for ultimately because of his faith. And that's often lobbed at Scalia saying he's just doing what the Pope tells him. So I hesitate to make those criticisms, but people say that stuff all the time. Roberts is a devout Catholic. Thomas is a devout Catholic. Scalia is a devout Catholic. They went the other way. Amber?
I mean, it seems like Alito just had a really big problem with someone protesting a funeral.
Yeah.
It seems like he really didn't like that. It was disrespectful.
Yeah, I think what Alito is basically saying is this would actually survive strict scrutiny. That was such an awful incursion, and the speech is such marginal value that even if you put this in strict scrutiny, the government loses. I'm sorry, the government wins here. Another case in the Snyder case, very tough case. Yeah, Anthony, let's do the Slants case. A little bit lighter facts.
Okay, so Simon Tam, the leader, he tried to file for a trademark for the name The Slants.
Okay, what did the government do to him?
They denied him at first. because it said it offended the, or is a negative term based on the shapes of eyes of certain persons of Asian descent.
Okay.
And then they went to court and.
Now, let's just dwell on this for a minute. Why did they find the term the slants disparaging? Did Simon and his friends, who were all Asian Americans, did they find the term disparaging?
No.
Why did they use that phrase for their band name?
Said they were trying to reclaim and take ownership of the stereotypes.
Yeah. So how many of you saw Simon last year when he came? This is not like Fred Phelps, right? This is not some sort of like racist running around telling people they're going to hell, right? This guy is a legitimate social justice warrior. He believes in reclaiming the name the slants and like depriving it of whatever sort of racial connotation they've had in the past. So he wants this to be something that Asians be proud of. He's very open about this. He talked about it last year when he came to South Texas. The government, though, denied him his license, and they denied him his trademark. And they said it was disparaging. And it wasn't disparaging based on his intent, right? He wasn't using the trademark to offend people. They said it was disparaging based on how people could perceive it. Now, this is a bit, maybe some of you remember. Does anyone remember why Simon said that the that the government thought it was disparaging? Does anyone remember what he said? He gave a very funny story. Actually, funny, well, for law school funny. But he gave a story about why the government thought it was disparaging. You remember?
A small group of people thought that it was disparaging. They took offense to it.
Yeah.
It's a small group of in the Asian community.
Yeah. So basically, someone put on some negative comments in a blog somewhere, saying they didn't like the band name. Remember this? Yeah. And apparently on UrbanDictionary.com, yeah, this is what they're looking at. On UrbanDictionary.com, don't go to the site if you don't know what it is. Someone wrote that this was a disparaging term for Asians. So literally, because of some blog comments and UrbanDictionary.com, the government said that this is disparaging. Right? Now, there's some problems with the government's decision here. Case, what's one of the problems with the government's decision here?
Well, like one of what they contend.
Yeah.
Okay, that they're saying it's government speech, not private speech.
Okay.
The first one.
Okay, yeah, let's start there. So when you have a trademark, this is a little bit beyond the scope of this class, but when you have any logo, so you're wearing a hat with a logo on it, I'm sure, right? Whose speech is on that hat?
Well, the government tried to argue that it was their speech. The court rejects that. It's the company's speech. Because I like how he goes through, like what does the government mean when they're saying just do it?
Yeah, exactly. So, I mean, you may not think about this, but any shirt you have, any logo, any brand you have, there's a little TM, you always have that little TM logo, right? That means trademark. So when you have a shirt with a logo on it or some sort of, slogan, and it says TM, just do it, right? No one is going to think that that's a government speaking, right? It's Nike speaking their brand. And the reason why it matters is when you deal with government speech, the government can restrict it however they want, right? The government's not under the obligation to convey certain messages. So there was a case a couple of years ago involving Texas. It was mentioned, it was called Walker versus the Texas Division of the Sons of Confederate Veterans. Always Texas, right? And that involves a Confederate group in Texas wanted to get a custom license plate made with Confederate flags on it. And the state of Texas said, no, you can't have that license plate. We find it offensive. The court held in a very strange 5-4 opinion that, drawn by Justice Thomas, that speech was government speech. And because it was government speech, they were under no obligation to issue any license plate they wanted. This case is different. Why? This case involved private speech. So this is obviously Simon Tam and his friends speaking. This is not the government speaking. All right, so Carlo, once we get past the question whether this is government speech or private speech, where do we go next, right? What's the next step?
I think that's when they move on to talk about viewpoint discrimination.
Okay, tell us about viewpoint discrimination.
It's talking about it prohibits disparagement of groups, I guess, or making sure that it's kind of even-handed. Yes.
Well, Carlo, why is this viewpoint discrimination, right? Why does prohibiting disparagement amount to viewpoint discrimination?
Well, because it depends really upon who is viewing that term as being disparaging.
What if instead of having the Slants, the name of their band was Asian Americans are awesome musicians, right? Terrible name for a band, but let's just say that was the name, right? Asian Americans are fantastic musicians, right? Would that trademark have been approved?
Probably.
No doubts, right? Is that disparaging to anyone? Now, what if it was Asian Americans are awful musicians? Terrible. That's the band name. Would that be approved under this disparagement clause?
If it says Asian Americans are awful musicians.
Terrible, yeah.
Probably not.
Right. So think about this, right? The same opinion. Are Asian Americans good musicians? If you say yes, they'll give you your trademark. If you say no, trademark denied. That is the essence of viewpoint discrimination. The government can't take a side in a debate, right? If they allow person A to say one side, they gotta allow person B to say the other side. They can't engage in viewpoint discrimination. Right? So when you lose viewpoint discrimination, you go on to strict scrutiny. And basically the government loses. Right? The government can't pick a side in a debate. They have to be viewpoint neutral. Any questions of the majority on that point? Government can't restrict speech based on its content or its viewpoint. They're often very related. Yes, Kelsey.
So they technically can't deny anyone a patent for
Trademark.
if it's not, or a trademark if it's not infringing on someone else's trade. Like that's the only.
There are a lot of rules about how to issue trademarks. I won't even pretend to explain them here. But one of their rules concerned disparagement, where even if the trademark was otherwise valid, no one ever used before, you're the first one, right? If some bureaucrat finds it disparaging under this rule, they deny it. And of course, that provision is unconstitutional. At the very end of the majority opinion, it's Alito, right? Alito says, "We have said time and again that the public expression of ideas may not be prohibited merely because the ideas are themselves offensive." And this is the idea again. You can't shut down speech because you find it offensive. And there's a next case, Texas versus Johnson. This case involved flag burning from Texas. Where else, right? So there was a flag burner in Dallas at the Republican National Convention in 1984, and the police arrested him for burning a flag. And the court said, no, burning a flag is a political protest, and you can't criminalize that act. Okay? So they strike down the disparagement clause. Any other questions of the majority? Kevin?
What about with commerce? How it was affecting commerce?
What do you mean?
I believe it says that if they would prohibit it, it would affect the commerce because they're going out there bidding, they make money, they facilitate their facilities by getting ticket revenue.
So there's a doctrine called commercial speech. It's not a doctrine that exists anymore, but it generally says when speech is of commercial nature, the court gives it less protection. That doctrine doesn't really hold much weight anymore. It hasn't been cited in over 30 years. So here, even though this is speech that's in a commercial nature, right, we're giving people the right to use a license to protect it. Now, let me just focus on this another case. So you all know about the Washington Redskins, right, the football team, and their name has been controversial for years, forever, basically, right? The Washington Redskins. What happens if the Washington Redskins lose their trademark? All their merchandise, right? People can start ripping off merchandises. So there's one ironic aspect of this case. If I want to start printing up T-shirts that say the slants on them, right? And I start printing them up, Simon's going to sue me, right? He'll take me to court. If Simon had lost his case and I start printing up these T-shirts, I would have won my case because he doesn't have a trademark. The effect of this case is to actually reduce the amount of speech available, right? Giving someone a trademark gives them basically a monopoly on the ability to use that word. So the end result, this decision protecting free speech, actually reduces my ability to use the word slants. Ironic, whatever you want to call it, but ditto for the Redskins. Trademark, which now they won't after this case, people would actually be able to use their phrase otherwise. This was a much better case than the Redskins case because you have very charming plaintiffs who make a good case, as opposed to a football team where they don't want to change the name because they don't want to lose money. And people do find the name. That's by and large. So any questions in the majority? Kevin, what's Justice Kennedy concurs? What's Kennedy talking about?
Mainly that it doesn't fall into the categories of like fraud, defamation, incitement.
Good. Yep.
And since it doesn't fall in these categories, it should be allowed.
Very good. Yeah, Kennedy goes a little bit further than the majority and makes the point of viewpoint neutrality a little bit more strong. But they're more or less on the same page, right? It's all the 8 justices, Scalia had passed away at this point, but all the 8 justices agree that you can't deny someone this government license merely because you find their viewpoint disparaging. So here we have again a situation where the court is very much protective of free speech. Thank you. Yes, Brendan.
What does incitement entail?
Okay. So there was a case called Brandenburg versus Ohio in the 1960s, and the facts of the case were like this. You had a head of a Ku Klux Klan chapter was giving a rally, and he said, at the end of the month, we're going to go march in Washington, D.C., and then we're going to march down south, and we're going to show them how awesome we are, right? Paraphrasing. But, he said, we're going to do all these awful things in a month, right? He was then arrested for what's called incitement of violence, that he was basically inciting or encouraging people to engage in violent acts, that is, marching on Washington and beating people up and doing these awful things, right? But he wasn't inciting people to do it right away. He was saying, let's do this in a couple weeks. And so what the Supreme Court said is, if you're inciting violence, it must be imminent, right? It's got to be something happening right now, right away. You can't shut down future speech. So the court actually reversed his conviction. Okay? So the only way you can have incitement is someone says, let's go and riot now. Right? So imagine, I know we've seen this before, this happened after Michael Brown's verdict in Ferguson, right? After the officer was acquitted, there was a massive riot in the streets. And Michael Brown's father-in-law actually got on top of a car and said, let's burn this motherfucker down, let's burn it down. That might be my exam question a couple years ago, I can't quite remember, but maybe it was a midterm question. But the question is, was that incitement? He wasn't arrested for it, but as he was saying this, people were getting very angry, getting very, a lot of emotion going on, and then if someone says something, it sparks it, and people start rioting. The problem is these are very hard convictions to make. To use another example, candidate Trump, when he was on the campaign trail, had these rallies, and they were very, very rowdy. And people got beat up at them. So there was one rally, I think it was in Kentucky, where there was someone there who's heckling Trump, and Trump said, get him out of here, get him out of here. Okay. Was he telling security to remove them? Or was he telling people around to beat the guy up? As it turned out, people started beating him up. And the person who was beat up tried suing Trump, saying that he incited violence. And there was actually a district court in Kentucky that let the case go forward. The Court of Appeals put that on hold pretty quickly. I don't think that's going to go anywhere. But the short answer is, it's very hard to prove incitement. Very tough to prove because you're effectively punishing speech. Okay. Other question? Answer your question? Good. Other questions? I think that was my exam question a couple years ago on incitement. I can't remember. Yes, Emily.
I remember from Simon's speech last semester, he said it was very arbitrary how this department was giving out or approving trademarks. That there were certain groups that they received their trademarks when, like, comparably had similarly disparaging names.
Yep.
So.
Yeah, like the Stormfront, you know, the group of neo-Nazis, they got their trademark.
Right. So I just thought that was.
Yeah, no, Emily, it's a very good point. Another aspect is that it's not applied consistently, where some offensive viewpoints were admitted and others were not. The government had very little chance of winning this case. Very little chance of winning this case. Only because it was so inconsistent with Snyder and other cases, right? Snyder was the most offensive speech you could think of, right? If that was allowed in, then slants is fine. Anything else on, yes, Andre?
Did the Westmoreland Baptist Church trademark all the stuff on their sign?
Oh, what a good question. I don't know. You should check on that for me. I'm not sure. I can't imagine other people in such a hurry to steal their messages, but I suppose. Thank God for IEDs.com. I don't know. I need to look into that.
They do like suing.
They do. All right. Anything else on Snyder or Matal v. Tam? No. All right. That brings us to our next provision of the Constitution. We've got an hour on free speech here. We're very unfortunate. I'm sorry. I wish I could do more. So the Constitution actually has several parts for the First Amendment. We already did this part. Congress will make no law abridging the freedom of speech. You all know that even though it says Congress after the 14th Amendment, the free speech provisions have been extended or incorporated to the states. The related provision, which I won't have any time to talk about, is the press, right? What is press? Well, you think of newspapers, but press literally meant the printing press, meaning that, you know, Gutenberg, right? You stamp words on a paper. That was how people communicate. Does the First Amendment provide any additional protection for the press? My opinion is that it does. The court hasn't always answered that clearly. Otherwise, why would press be there? But that raises a thorny question of who's press? Bloggers, tweeters, right? Who's press? That's all you get for that. These other provisions, the right of the people to peaceably assemble, and the right to the government to petition for grievances, to redress of grievances. These provisions have been used to create what's called a right of association that you can choose who to associate with. So, for example, if you're a member of the local NAACP chapter, can the government make you hand over your membership rolls? Now, why does the government want your membership rolls? To intimidate you, right? Who wants to give your membership rolls to a bunch of people in Alabama in the 1960s or in 2017, right? Sorry. If any of you ask me to sign your yearbook, the answer is no. But these provisions have been used to establish a right of association. If you got that. For the rest of the class, we'll focus on the first two parts, the religion clauses. So it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And these two provisions often work in tension and together. So I've given you some readings, very brief, of how to understand these provisions. And we'll do the free exercise clause first. So David, what does it mean that Congress can't make any law that prohibits the free exercise of religion? That's what they refers back to. What's that getting at?
People are entitled to their religious beliefs and to practice their religious beliefs and not be, I guess, restricted from exercising their religious beliefs.
How does one practice religious beliefs?
That's a great question.
Oh man, it's a fantastic question. That's why I asked it, yeah.
I mean, whatever, that's kind of, I don't know.
I asked it, yeah.
Like, whatever, I guess, whatever, your religious doctrine tells you to do and you follow it.
Evan, want to take a stab? What does it mean to exercise your religion?
Yes, following through on acts that are required of you.
Like what?
I guess to pray, for instance, if you're required to pray, or if you're required to perform like a ceremony perhaps, or?
So
maybe
does
absence of
does
it?
free exercise only apply to stuff you would do in a house of worship?
No,
No. Why not?
because you may be required to do something that's not social worship.
Give me an example.
Some religions don't allow you to eat meat, and you won't be eating meat. You could not be eating meat yet, but eat meat at like work or so we don't have to eat.
Okay, but let's give you another example of it. Let's say your religion doesn't let you consume alcohol or even come into contact with alcohol. And let's say you're an Uber driver, right? And someone gets into your Uber with a can of beer. Turn away. Decline to give them a ride. Or, for example, let's say you're a truck driver, right? Can you decline to haul beer in your cab?
I'll say no in this case.
Your boss fires you. If the boss fires you, you know what, Evan? You don't want to haul beer, I'm going to fire you. Any problem with that?
I'll say no because it's not the government.
Okay, then you try and seek unemployment benefits in the state. And you say, look, I was fired because I wouldn't haul beer and my religion doesn't allow alcohol. And the government deny you benefits. So usually, you might not know this, I hope you don't know this, when you get fired from your job, you don't get unemployment, right? Everyone knows that? Right? When you get fired, you can't collect unemployment because it's your fault. That's why whether you quit or fire is a very big deal, right? But if you get fired for cause, you can't. If you get laid off, different story. So, you were fired, disobedience.
Well then,
Yeah, Adam, so what does this mean free exercise? How does one exercise religion?
by whatever means they feel they want to. I mean, whatever your belief is.
So, using peyote, which is a controlled substance, is illegal. My religion requires me to use peyote. What?
Cut it Native American land. Everyone on the
That's
reservation.
called America.
Well, we're in the reservation.
I live in Portland.
Okay.
And I'm a Native American. Can I use peyote?
Illegal drug?
I'm sorry?
No, it violates. An exercise of your religious beliefs cannot violate, a criminal statute or some other policy.
Well, why isn't that criminal statute unconstitutional? It violates my free exercise. Doesn't the free exercise clause trump any criminal statutes?
No.
So you're saying that a state statute is above the First Amendment?
Well, there's federal drug enforcement as well, so.
So a federal statute is above the Constitution?
No, but,
Brandon, what if this was during Prohibition and no alcohol is allowed, and I wanted to drink sacramental wine in my religious service? Could I have been thrown in jail for drinking sacramental wine during communion? During Prohibition?
According to employment division, it had to do with the negative protection, I believe.
Well, actually, it's only a trick question. By what means was Prohibition employed? How did we get Prohibition?
An amendment?
Yeah. So what's the interaction between the Prohibition Amendment and the First Amendment? Could Congress have prohibited sacramental wine?
Yeah.
Yeah, it could. But here's the wrinkle, Brandon. Just take a guess. Do you think that during Prohibition, sacramental wine was illegal?
No.
No. Why not?
Because, especially at that time, the church was powerful.
Yeah, so here's the thing, right? Even during Prohibition, sacramental wine was allowed. There was a accommodation made. So generally, alcohol was prohibited, but you could have sacramental wine. Right? Was a similar exemption made for Native Americans who use peyote? And the answer is no. So that gets to the question, why not, Amber? Why was a carve-out made for sacramental wine, but nothing was made for people like Al Smith who wanted to use the peyote?
Well, the court did talk about somewhat about how there was some states that were making it, but basically they said that it wasn't something that needed to be done, essentially. So it wasn't a part of their actual religious ceremony. So it wasn't like going to church, you drink the sacramental wine during church. It's something that's a part of the actual ceremony in church. But this was kind of a separate instance, something that they did for their own spiritual.
Does that make it any less protected? David, your hands up? What was that? Your hand was? I'm sorry, David. Oh, David. Okay, David. Does it matter if the peyote use was something secondary, spiritual thing wasn't like a community one? Should that matter for purposes of the First Amendment? No, it shouldn't. David, you want to give us the facts of Smith, please? The Flight Division versus Smith?
So, you had Smith who was using peyote in conjunction with his Native American church. I think he's in like a healing ceremony or something like that. And he got fired from his job.
You know what his job was? Emily, what was his job?
Drug rehabilitation.
Yeah, he was a drug counselor. So here's the story. It's actually very sad. So Al Smith was a Native American. I think he didn't grow up in that faith. And he became an alcoholic. He became very down on his luck. And he actually found redemption through religion. And he actually sobered up and became clean by going to these Native American ceremonies. So the irony, though, is basically got this job as a drug counselor because look, he got clean, right? He's a good success story. But he was then fired for his job because they found out that he was using peyote. Now, there's nothing wrong with him getting fired. There was a criminal statute which prohibited that. The problem was when he went to go apply for unemployment benefits. So I went here. I was in Salem, Oregon last year. I visited the Oregon Department of Employment. It's a nondescript building. The lady at the desk was so confused. I was taking pictures. They were like, "What are you doing?" I'm like, "Supreme Court stuff. Don't worry." I just all the time. I go to places and they're like, "What the hell are you doing?" Kevin?
So
what?
where does the press, like I know some buildings you're not allowed to take pictures.
I walked right into the lobby.
But like with federal buildings, I believe you're not allowed to go on their premise and take pictures inside of it.
Maybe.
So is that like First Amendment-ish?
My perspective, and this is a government building, I have a First Amendment right to be a journalist in my own blogging capacity, so I'm going wherever I want. She was more confused than anything. She's like, "Why are you here?" I'm like, "Supreme Court, I'm taking a picture." So it's a nondescript building in Salem, Oregon, a few blocks from the Capitol. But the facts of the case there were he applied for benefits and they were denied. Okay. So Aaron, what was the precedent on the books? And it was the first case I had to read in this topic that probably Smith was hoping he could rely on here.
Sherbert versus
Yeah, I did his order and delivery, don't worry. What was Sherbert about?
That was about a Seventh-day Adventist who
Good.
denied unemployment benefits by South Carolina because she refused to work on Saturdays.
Very good. Okay. So Sherbert v. Verner, 1963, was a Brennan opinion and involved a Seventh-day Adventist, and they celebrate the Sabbath on Saturday instead of Sunday. This person applies for unemployment benefits, and she said, "Look, I want unemployment benefits, but I won't take a shift on Saturday." And the government said, "Hey, if you're not willing to take a shift on Saturday, that means you're not really looking for work, and you deny benefits." So what Justice Brennan basically held is that this policy imposes a substantial burden on her free exercise, and it was unconstitutional. And here he employs strict scrutiny, right? And the argument's this: what's the big deal? Everyone else gets one day off that Sunday. Would it be that burdensome to the government to give her one day off on Saturday? And Brennan says it wouldn't, right? This law is not sufficiently narrowly tailored, right? This is how strict scrutiny often works. It wasn't sufficiently narrowly tailored, okay? I gloss over that case because Justice Scalia basically overruled it. The court doesn't expressly overrule, Sherbert, but they come really close to it, right? All right, Jason. So what does Justice Scalia do here in Smith?
So essentially, I'm sorry. He said that the general applicability doesn't violate the free exercise clause, that the states didn't have to allow people to use peyote for their religion, for them to still be able to practice their religious.
Well, let's take this one step at a time, right? You mentioned a law of general applicability. What does that mean? Well, what's the law of general applicability here?
Appeals to all and it's not singling out one group.
Why is this law of general applicability?
Because it's everyone can't use peyote, not just this religion.
Is it just peyote?
No, it's several drugs.
Ah. So this law basically says if you use controlled substances, you can be denied benefits, right? It does not just single out peyote. If the law said only if you use peyote, nothing else, right, Jason, I'll ask you that question. What if the law said, if you use peyote, you can be denied benefits, if you use crack or marijuana, whatever you're calling. What inference would that give rise to?
Peyote be connected to the religion.
Right. It's a product, a drug that's very closely linked with one faith. Everyone know what peyote is? It's like this cactus. I've never used it. I hope no one in this room has. But what?
Seeds from a cactus.
Yeah, this thing gets you high. I've never used it. I had a student who was in a ceremony who's used it before. He said it's very unsettling. This is not like a fun drug, right? Because basically you're vomiting. It's really rough. You know, Andre?
No, sir.
You're nodding. you were nodding, but I'll leave you nodding aside. Just shaking your head. Right. So this was a law that was only directed at a single drug, right? There may be suspicion, but this is all controlled substances. So as a result, this law is one of general applicability. What does Justice Scalia do with the law of general applicability? How do we understand that?
Was it the test that he knows that the government actually regulates general conduct, including religious conduct, is valid?
Is a law, let me ask the question again differently. If a law is of general applicability that applies everywhere, does it get strict scrutiny?
No.
No. How do you review it?
In a much more broader sense instead of
Basically, that's right. Rational basis review, right? The holding, the test of Smith is that when the government engages in an act of general applicability, even if it burdens religion, it's subject only to rational basis review. Okay? This basically overturned Sherbert, because Justice Brennan employed strict scrutiny for these sorts of laws. Now, there's a potential difference between Sherbert and Smith. Scalia tries to make it. Anyone know what it is? Or anyone want to reach at it? How does Scalia distinguish Smith away from Sherbert? I don't think it's very persuasive, but he tries.
We don't have to.
Scalia with the majority. Smart ass. Yeah.
Can you say that Sherbert only applied to Sherbert?
Basically, you're not exaggerating too much. He limited Sherbert to the facts.
One difference is Sherbert involves civil, this is a criminal case, right? He makes up the distinctions, but they're not very good. But the effect of Scalia's opinion in Smith is to more or less overturn Sherbert, right? So now, I don't want to get to you in a second. If you have a law of general applicability, right, that applies across the board, you give it only rational basis review. Okay.
Doesn't he basically say that we're only gonna shoot down your religious beliefs if there's a higher compelling government argument?
Well,
and that's his broad stroke.
What he does say is, what if it's not a law of general applicability? Right? So, I think, John, you're next. I think you're fully down here. Am I going the right way? No. Jay, who's next? Sorry, Kelsey, I think you're next. All right, Kelsey. The entire wing is
I
absent.
think you usually don't do J. But we let you just keep going.
John, are you next?
You skipped it, okay.
Kelsey, okay, fine. Kelsey, let's consider a different case. It was decided a couple years later, right? This case involves a law that prohibited forms of animal sacrifice. Okay? Now, it was styled as a law concerning hygiene, that you couldn't kill chickens in a certain fashion. But the way this law operated is it only targeted a certain type of slaughter. So, have you ever heard of the Santeria faith? It's an Afro-Caribbean religion. And part of their sacrament is they do animal sacrifice. They kill chickens. Right? That's part of the religious sacrament. Would this law be one of general applicability? In that it targets with precision the sort of ritual slaughter used in this religion.
No. Maybe on its face it looks like it's...
But does it apply generally to all people?
Yes.
Mark, what do you think?
I don't believe that it would.
Would what?
Apply to all people.
Okay. Is it targeting one faith?
It is.
Why?
Because they're the only ones that are on the record.
Yeah. So if you have a law, right? If you have a law that targets one faith, like the Santeria case did, it is not a law of general applicability. Okay? It is not a law of general applicability. And because it's not a law of general applicability, you go to strict scrutiny land. And in strict scrutiny land, the government loses. Mark, you're wincing. What are you wincing at?
Strict scrutiny land sounds like an awful theme park.
It is. So I'll tell you a funny story. My colleague, Randy, actually wrote an article called Scrutiny Land, which is where I got it from. But back on April Fool's 2010, I wrote a blog post. It was an April Fool's joke. And the joke was, I was going to build a Constitution theme park called Constitution Land. Right? And it had all these rides, like Lochner's Bakery. It was funny. You can Google it. The funny part was people didn't realize it was an April Fool's joke, that I was serious. I should have known early on my power, right? So I get a cease and desist letter from this guy who had actually trademarked the name Constitution Land, and he ordered me to take down the blog post. I was dumbfounded. It was published on April 1st. It was obviously a joke. So I wrote the guy a letter back to his lawyer saying, it's a joke. He actually retained a lawyer to send me a cease and desist letter. An awful theme park indeed. Yeah, but I made graphics. It was a really well done post. I had an elaborate setup. This was 7 years ago. Adam?
So you're chicken killers, but
Chicken killers.
you're chicken killers.
They're religious people, the chicken killers.
That actually is general applicability because isn't the argument that there's health concerns for the general public?
But it didn't prohibit slaughter in general.
Right, there could
It only prohibits
because of the way they were doing it.
So if you pass law saying you can't kill chickens in city limits, would that be permissible?
I think so.
But that's not the law said. It only prohibited slaughter in a specific fashion that overlaps with how this religion engaged in their rituals. So you could have a slaughterhouse across the street that was just fine. But if you killed one chicken in this fashion, with the neck, whatever else, that's illegal. Right? They basically wrote a law that only prohibited the type of slaughter used in this one. And that was prohibited.
Make sense?
It does, but I also think it's potential to have an argument of, there's a reason why there aren't slaughterhouses in the cities. It could have been something in the way they were killing the chickens that had a public policy.
And if they wrote that statute, they could have passed it. That's not the statute they wrote.
No.
All right. So the holding then of Smith, right? The holding of Smith is if this law is generally applicable, it applies evenly across the board, the law gets only rational basis review. But if it's not of general applicability, it targets specific religions, it gets strict scrutiny. So deciding whether something fits into the strict scrutiny bucket or the rational basis bucket is very important, of whether it's one of general applicability. The effect of Smith, again, this was a Scalia opinion, is it basically wiped out the free exercise clause. After Smith, unless the legislature is dumb enough to write a statute targeting one faith, the free exercise clause has no weight. This is Adam's question, right? If you're a smart legislator and you're trying to go after a religion and you figure out some way to do it in a neutral fashion that doesn't look like you're targeting them, you get rational basis review. So Scalia's opinion, I think Kevin said before, it's Roman Catholic faith. Scalia's opinion is he wiped out the free exercise clause of the Constitution. It doesn't have much weight anymore. There's been a long-standing criticism of Smith. I go back and forth on it all the time. Still haven't made up my mind yet. But the effect is, as long as you're not a stupid legislator writing a dumb bill, you're probably going to get passed by.
I think maybe the reason, besides the criminal aspect, why they, I guess for extreme religions to be able to,
What's an extreme religion? Bungee jumping and skydiving like that?
I mean, something you might see on the Discovery Channel or something like that, but...
Westboro Baptists?
Just people, trying to do crazy things under the, the sky.
The Church of Marijuana.
Yeah, something like that,
Okay.
and so I think that's maybe what...
I heard the Church of the Pastafarians. Did I hear that?
What?
Church of the Pastafarians. Did I mention that last week?
Pirate
regalia's in the car.
Yeah, Lacey?
The colander on it? Is that what
Yeah, so, Adam, one at a time, please. Thank you. So, the Church of the Pastafarians, it is a church that was founded somewhat recently, and their deity is a flying spaghetti monster. And their symbols, they wear a colander, spaghetti strainer on their head. And their thing is they want to take photographs of their driver's license wearing this spaghetti strainer on their head. And they've actually succeeded in a number of states in that they are an official church, and that it would not impose any sort of burden to put this thing on their head. Okay, now you're smarter because you're in law school about the spaghetti monster. If there's anyone in the room who's a member, please speak up. Or that hasn't happened yet. One day it will happen. Okay, so any other questions on the Smith majority? Right? Is O'Connor's dissent in your book or not? No. See, it will be next go around, so I'll summarize it for you. What O'Connor basically says is this decision wipes out the First Amendment. And it will have a very distinct effect. So I asked earlier about sacramental wine. I asked him, Brandon, would Congress have criminalized sacramental wine? He said, of course not. The church was powerful. He's right. If you are a fairly popular faith, you can seek exemptions from the legislature, right? They'll just carve out sacramental wine. But if you're in a minority faith like Mr. Smith over here, not too many Native Americans running around in Congress, right? It's going to be harder for you to get an exemption put in. So what Scalia's opinion says is if you want to make an exemption to a law-based religion, go to Congress. Well, Congress says that only works if you have enough pull in Congress to actually get legislation passed. Okay. Now, the aftermath, though, of Smith is a fascinating study. In 1993, only a couple years after Smith, Congress enacts RFRA, which we mentioned before. We talked about Bernie v. Flores, a good review. Chris, do you remember what RFRA is? You remember what RFRA is?
Religious Freedom Restoration Act?
Very good, yes. Religious Freedom Restoration Act. Okay, Lacey, what did this law do?
Crap. I know it was designed to apply broadly to all the laws in Reg?
Yeah, good. Anyone else want to take a stab? Martin?
It supply the undue burden test. That
Substantial burden.
Substantial burden.
Very good. Yes, very good. Yes. Undue burden was Casey. Well, you're in the ballpark. Yeah. So RFRA was passed in 1993. It was signed into law by President Clinton. It was enacted virtually unanimously in the House and the Senate. Right. Very popular law. And what RFRA purported to do was to, as the name suggests, restore religious freedom. At a high level, it tried to bring back the Sherbert versus Werner test, right? It tried to reinstate Justice Brennan's opinion, Sherbert v. Werner, that if the government wanted to impose a substantial burden on your religion, they had to use the least restrictive means. Okay. The court struck RFRA down, though, in part. In a case called Bernie v. Flores, we cited this one. Remember the church in San Antonio that wanted to expand, they couldn't get their permit? So the court struck down RFRA saying, hey, you guys want to redefine the First Amendment? No. We define the First Amendment. The court struck down RFRA, in part, as applied to the states. So even though Congress tried to get rid of RFRA, the Supreme Court said, I'm sorry, Congress tried to get rid of Smith, the court said, no, you can't do that, only we can do it. Texas, though, and a number of states actually enacted their own RFRAs on state legislation. So Texas has a RFRA that half the states do, half the states don't. So as it stands now, about half the states have this heightened protection for religious freedom. But if you're not in one of the states that has this protection, you're stuck with Smith. And Smith doesn't provide very much protection at all. So questions on Smith and the free exercise clause. Crystal?
I was a little bit confused whether this was an establishment clause case or a free exercise clause case, or it was a mix of both.
Well, Smith was only a free exercise case. Why do you think the establishment clause is implicated?
Because he wasn't able to smoke peyote in court.
Well, why would that be an establishment clause issue? There's a reason. I can think of a reason why it would be one. Crystal, let me ask you a question. What happens if the government makes an exception to the law and they say that everyone is subject to military service except for Amish people? Right, which is how the draft operated in the 70s when, David was in vitro, right? Can the government do that, say, we are going to require everyone to get into military service except for the Amish and the Quakers?
No.
Why not?
Because it would be singling out just the Amish and the Quakers.
Would that be an establishment clause issue? Oh. All right, let me ask you another question, Crystal. This is your turn, by the way. You have to be next, so I'll stay on you for a minute. Let's say the government says we are going to impose a tax on everyone of $5 a year to pay for religious schools. How do you characterize that case? Is it a free exercise clause or an establishment clause? Or both? Why is it both?
It's establishment clause because it's pertaining to specifically the $5 to whatever that $5, whatever institution that $5 is going to.
Okay.
So that's the establishment.
How's it exercise?
Because if you're an atheist or if you don't have a religion, you shouldn't have to pay.
So I think Crystal's questions are very astute, right? Very often the establishment clause and the free exercise clause run into each other very hard. And they often overlap and they entangle. So the example I gave, the $5 one, that's from a Madison, right? That's from the Memorial and Remonstrance, which was written even before a Constitution was ratified. So the Memorial is not in any way an interpretation of our First Amendment. It was written before. But it teaches a few lessons, right? Virginia tried to establish a tax to pay for religious instruction. Now, does that violate free exercise?
Or does that amount to an establishment of a church? And arguably there's a little bit of both, right? What if you're an atheist? What if you're Jewish? What if you're Hindu, right? You may not agree with teachings of any church, and you may not want to fund it. So it actually violates your free exercise, perhaps, to have to fund this church. But why are they singling out just certain Christian churches, right? Is that an establishment of religion? Which leads us to our second question. What does it mean that Congress shall make no law respecting an establishment of religion? Right? So one point at the outset, I'll mention this very briefly. At the time of the framing of the Constitution, believe it or not, many states had established religions. Right? States had established churches. It was an official church of Maryland, of Connecticut, etc. I think the best reading, and the one I've not seen a strong response, that as originally understood, this provision was a federalism provision. It was designed to prevent Congress from messing with state churches. That if Maryland or Connecticut wanted to have a state church, Congress couldn't mess with it. I think that's a better reading, but it's subject to debate. This is what Justice Thomas argues. But after the 14th Amendment, this provision was incorporated such that states can't make any laws respecting the establishment of religion. Now, I think, Martin, you're next. What does it mean to make a law respecting an establishment of religion? How is the court interpreting that phrase?
Regarding religious organizations.
What do you mean regarding?
Involving. I feel like I'm just being a thesaurus.
What does it mean established? Let's start there, Mark. A little easier.
So when talking about establishment, it means like the church or like other organizations that aren't just someone saying, I believe this. The way I understood it.
What does it mean to establish a church?
Like the formation or creation of the church.
Actually, want to take a step? What does it mean to establish?
Like an endorsement of the, like endorsing it?
So, does that mean the government can endorse religion? What does it mean to establish religion?
To say that this is the religion of the United States, or
okay, so an official
or it
religion.
Can't be the religion of the United States.
What if they don't say there's an official religion, but they say we prefer the Catholic Church because we're going to give some subsidies to the Catholic Church? Is that establishment religion?
Yes, because I know that government does give funds to religious organizations, that it has to be not equally divided. I don't know the right way to say it, but like there can't be any favoritism, I guess, given to anyone.
Emily, what does it mean to establish religion, according to the court's precedents at least?
Well, I would agree with my classmates. It means to establish and endorse a religion and advance its
So,
teachings.
in God we trust, right? Every piece of currency. That's what it says. And any piece of U.S. currency you see, it says in God we trust on it. Is that an establishment religion?
Oh man. No.
Well, why do you say no? Isn't that endorsing God, monotheism?
No, it's just a saying.
Just a saying, really? Has no meaning? Do you think atheists would agree with that?
You're asking a tough question.
I'm asking you. Let me ask you another question. Pledge of Allegiance, right?
Yes, what about it?
One nation under God.
Well, they acknowledge, the framers acknowledge that we have a creator, that we all have our own inalienable right to believe in our own God, but Congress cannot make a law establishing one religion that everybody has to abide by.
What about just monotheism?
I'm sorry?
Monotheism, belief in one God. Can they recognize that? This is Scalia's point in the McCreary County. John, what test does a court settle on when the Establishment Clause? What is a violation of the Establishment Clause? How do you violate it?
They're looking at the lemon test. It's 3 prongs.
Lemon test. Oh, our flavor. What's the lemon test?
Off of memory, when I go back to the prongs, is there's a risk of entangling the government and religion. A little bit prong.
What's one that matters most in the McCreary County case?
Purpose.
So what does secular mean? This is a word which defines in your book. I note about it. What does secular mean, John?
Do you think it's defined in the book?
It's not.
Oh, I was going to say, I missed that one.
What's the difference between secular and sectarian? They're very similar, but they're very different.
Well, secular is, you have some, well, as you said, policy decision, but secular, it's devoid of some sort of religious flavor to it.
Okay, good. And what's sectarian?
Sectarian is denoting or
let me Google. He's Googling it. He's Googling it. It's fine. Read it again.
Denoting or concerning a sect or sects.
That's actually not a very good definition.
Or a member of a sect.
In this context, so if I tell you that secular and sectarian are the opposite of each other, which is which?
In regards to religion? Secular is devoid of religion. I guess sectarian would be.
There you go.
Religion.
Okay, very good. So, secular means no religion. Sectarian means religious. They're opposites of each other, at least in this context. So, Lacey, the court says in McCreary County that to comply with the Establishment Clause, a government action must have a secular purpose. What does that mean for a law to have a secular purpose?
Maybe like non-biased.
What do you mean non-biased?
Not preferring one religion over the other. You get to choose.
Not preferring one religion over the other. Good. So how do you know if a government action prefers religion over the other, or religion over non-religion, I should say? How would you know?
They allow certain religions in their.
Well, let's talk, Lacey. What are the facts in McCreary County? Let's start there.
So the 10 Commandments are placed on a wall of the public courthouse.
Okay, good.
And they sued that it is a violation of the Establishment Clause.
Okay, good.
The ACW.
Right. So the facts of this case are a little bit different, and again, I'll be back in the 3rd edition. But there were 3 versions of the display. So the first display just showed an abridged version of the King James 10 Commandments. They got sued by the ACLU. And they put up a second version of the display. And the second display had other items, for example, President Lincoln's designation of the day of prayer, President Reagan marking the year of the Bible, the Mayflower Compact. So you have basically the 10 Commandments surrounded by other religious symbols. A court issued an order saying take that down. Then there was a third display. So you have the 10 Commandments, you have the Magna Carta, the Declaration, Bill of Rights, Star Spangled Banner, Mayflower Compact, the national motto, which is "In God We Trust," just a saying, and the Kentucky Constitution. Does, Rachel, the 10 Commandments there have, according to the majority at least, an improper purpose?
No, they didn't.
The majority? Was the majority hold? Does this law have a secular purpose?
No, the purpose was to advance religion.
Okay, how does the court know the purpose was to advance religion?
Because I guess those, like the 10 Commandments, I identified the non-believers as outsiders. So what I have, and it encroached on religious liberty, and it made divisiveness in a court where it should be like a public area.
You seem incredulous.
I don't know if that's like a great argument.
Well, what specifically about the monument, about the display, told the court that the purpose here was not about a sectarian purpose, not a secular purpose?
Did you say not secular?
I'll say it again. I'm sorry. I was about to sneeze. I tried brushing it out. It didn't work. Rachel, let me ask the question this way. Can the Ten Commandments ever have a non-religious purpose? Could a display of the Ten Commandments ever have a non-religious purpose?
I don't think so.
Why not?
Because it's rooted in the Bible, which is a religious document.
So what if we had a statute that said, thou shalt not steal? And another statute that said, thou shalt not kill?
Yeah, I
Thou shalt not sign yearbooks for minors, right? Thou shalt not covet thy teenage mole, right? I mean, you have these, you see where I'm going with this, right?
Yes.
So where am I going with this? Does the Ten Commandments have a secular impact on the law?
They do, yeah. I think so. A lot of our laws are based on that.
Yeah, that's what I was looking for, right?
historically.
So, one of the arguments in this case is that the Ten Commandments in particular has a very strong foundation in our legal system. I think a couple of you said you went to the Supreme Court. Anyone ever been there?
Mm-hmm.
Did you ever notice the Ten Commandments displays when you were there? So right above the Supreme Court, there are all the lawgivers. You know, there's Hammurabi and Solon and all these great lawgivers. There's Moses holding the tablets with the Hebrew written on it. Actually, one of my friends clerked in the court, and for his wedding present, I got him a painting of the Moses holding the tablets with the Hebrew on it. So it's up there, right? So, oh, Jessica left. She absconded her final appearance. Daniel, sorry, you're next. Does Justice Souter, is he troubled by the fact that the Supreme Court has representations of the Ten Commandments there? Yes. Justice Souter? The majority. Is the majority troubled that the Ten Commandments is displayed at the Supreme Court?
No.
Why not?
The context is not,
What's the context?
they weren't trying to equate them with the documents.
So why is the Ten Commandments okay at the Supreme Court, but not okay in the Kentucky courthouse?
I guess the display is different from trying to compute meaning or they're trying to get it meaning, I guess, in the way that they're.
Andre?
It's the intent.
Okay, what's the difference in intent?
Well, there's a historical intent with Moses on the ceiling, and here they're just kind of trying to hide a religious message among a bunch of secular stuff.
Yeah, so what Justice Souter says is that the true purpose of this display at the Kentucky courthouse is not to promote the rule of law and promote the rule the Ten Commandments has in Western civilization. Souter writes that the purpose of the Ten Commandments display is to advance religion, and that all this other stuff is merely just a pretext. It's not the real reason why we have it. And he makes a big deal about the progression, right, leading up to the third display. Right, the first display was posted with a preacher there and talking about the existence of God. And the second display was enhanced with even more religious symbols. The third display was a little bit safer in that they surrounded it by other documents concerning the law. So Elizabeth, there's one point that comes up. Is Kentucky ever allowed to post the Ten Commandments? In other words, could McCreary County ever find a way to post the Ten Commandments in a permissible way? Could they ever do it?
Yeah.
How?
If it wasn't, the purpose wasn't religious.
Well, I'm asking, what can they do to make this better? Do you think there's anything that the people in this community could ever do to allow them to post this Ten Commandments? Or will the court always stop them? Yeah, so Justice Souter has this one line that says, "We do not decide that the county's past actions forever taint any effort on their part to deal with the subject matter." In other words,
they're not permanently disabled from posting the 10 Commandments, but from my reading they are, right? Because anything they do will be rooted back to the first version. And the reason why I'll mention this briefly, I haven't talked much about the travel ban. That's an issue that's going through the courts right now. On the campaign trail, President Trump, or candidate Trump, made a lot of statements how he wants to shut down on Muslim immigration to the U.S. And then when he came to office, he instituted a travel ban, limiting travel from 6 predominantly Muslim nations. The policy has now gone through 3 iterations since the inauguration. Much like this one, 3. And one of the arguments is President Trump forever disabled from instituting any sort of travel policy affecting predominantly Muslim nations? The courts have more or less ruled against the president, saying that he's not quite forever tainted, but it's going to take something very serious to move past the initial animus. I think those cases are probably wrongly decided, but we'll see if I'm wrong later this year. So any other questions on the majority, Justice Souter?
What if they...
Go ahead. Yeah, thank you.
What if they, like you said, in the Supreme Court, there are multiple examples of what our foundations of law are. What if they, like, hung more examples?
Copy the exact symbol of the Supreme Court.
Yeah, than just the 10 Commandments.
I suppose if they copy the exact same symbol of the Supreme Court, they might be okay. Maybe. I'm not even positive about that either. I think they'd be trying to be a little too cute by doing that, but they might pass through. So the other question is the majority. All right, let's go Scalia. Elizabeth, what's Justice Scalia talking about?
I guess they're saying that each time that they put out the Commandments again, each incident should be construed as
Okay. Well, but what does Scalia say about history, though? What's his broader point? What's Scalia talking about history? Yep, very good. So Scalia's dissent is largely about history. And he traces it that we've had a very strong connection to religion since the founding days. George Washington gave a Thanksgiving proclamation, giving thanks to God, giving God we trust. One of the first actions of the first Congress was to hire a chaplain to give prayer. And what Scalia is saying is this is a long tradition of religion, and the court's precedents are not consistent with that. To this, Justice Souter basically replies, we don't care, right? That for at least 50 or 60 years, the court has been ruling in a fashion to exclude religion from the public square in this fashion, and we're not going back to it. This is a battle that Scalia has lost, and now he's not with us anymore, so he lost for sure. But he waged this lonely battle for several decades. So any other questions on McCreary County? Yeah, Brandon.
The amendment says Congress shall make no law respecting an establishment. I mean, my initial thought is there's a big difference between passing a law and placing, something on a wall. Am I wrong in my understanding of the
You're not wrong. You're not wrong. Generally, that phrase "law" has been extended to any sort of state action, but you're not wrong. On the same day that McCreary County was decided, another case was decided from Texas. So has everyone been to the state capitol in Austin? David? You know what's on there, right? Have you seen what I'm talking about? Anyone ever seen the 10 Commandments monument in Texas? Capitol? How big is it?
Emily?
6 feet.
Yeah, it's huge. It's like as tall as I am, right? It's this humongous granite marble statue, right, of the Ten Commandments. On the same day that the Supreme Court told McCreary County they had to take down the Ten Commandments monument, another majority of the court told Texas they can keep their monument. How in the world does McCreary County lose but Texas wins?
Texas.
Ask Justice Breyer. The rule, I think, to distinguish them is if it's something made of stone, you leave it in place. If it's not hanging on a wall, I'm actually not being facetious. Justice Breyer wrote a concurring opinion in the Texas case where he said, well, it would cause a lot of disruption to remove a monument that's been there for decades, so we're going to leave that there. Emily, you don't look happy with that one. Read it. No, Breyer's concurring opinion. I'm not making it up. I'm not exaggerating. Yeah. Mark?
Could it be one is outdoors and one is indoors?
Well, it's right between the Capitol and the Supreme Court of Texas. You can't miss it walking past. It's humongous, right? Yeah, Kevin.
So how would that apply to all the monuments being pulled this past summer and spring?
Well, those aren't being pulled because of the establishment clause. So it's not really on point. But there was recently a Latin cross in Maryland, like a 50-foot Latin cross, a monument to service members killed in World War I or World War II. I can't remember. Maybe it was Vietnam. I'm drawing a blank. But I'm sorry.
World War I.
Thank you. World War I. But these cases do pop up quite a bit. Andre?
Was this related to the satanic statue stuff that was going on, where they were kind of trying to bait them into getting upset by placing the satanic statues on the courthouse lawns? You know what I'm talking about?
I think in Florida?
Oklahoma.
Oklahoma. So what is the case? I think I'm familiar with it.
I think they were just trying, like, if they had a statue of the Ten Commandments, they were arguing that they should be able to statue of Satan.
Perfect. This is a good way to loop up the entire class, right? So let's say the government has a park, right? And there are different types of statues, like in the Texas Capitol State Grounds. They have a Ten Commandments monument right there. Are they required to put a satanic statue as well? No, this is what's called the government speech doctrine, right? When the government is a speaker, they're not required to be viewpoint neutral, right? This is like the license plate case, right? If they're making license plates, they can pick and choose which license and which messages they want. So they can have a license plate that says, you know, I love Dr. Pepper, which they do, but not a license plate that says Confederate flag on it.
What did you call it?
The government speech doctrine.
Speech doctrine?
Government speech, right? When the government's a speaker, they're not required to be viewpoint neutral. So, if I may summarize the class for the day, almost done. Sadness, right? The First Amendment has a significant amount of case law on it, and I encourage you to take a full class. Under the Establishment Clause, the general rule is neutrality. That when the government deals with religion, they have to be neutral. They can't show any sort of endorsement or favor of one religion or the other. Under the Free Exercise Clause, as interpreted by Smith, again, the rule is if government's neutral, right? A law of general applicability, you treat all religions the same, you have a rational basis review. If religion's targeted, you go to strict scrutiny. The Speech Clause, the Press Clause, as well as what's called the right of association, is protected much more fiercely. And generally laws that discriminate on the basis of content or viewpoint are subjected to strict scrutiny.
Well, that just occurred to me. Wouldn't it actually be the most neutral for the government to say, you know, like, in God we trust, as opposed to just taking it out, because that is inherently choosing atheism?
Oh. Is atheism a religion?
Depends on which atheist you ask.
That's actually a very good question. There's a bit of debate about that one. Yeah, so would the government's not required to say in God we trust, but you're saying if they remove it, are they favoring secular humanism, right, as a religion? Yeah. Maybe. We'll see if that's the next round of litigation. What else we got? Yes, Jason.
They say in God we trust, the Christian would be Santa Claus.
Have you seen Miracle on 34th Street?
Many, many times.
It's a good scene. What else? Anything else? Nothing else? All right, thank you for a great semester, appreciate it.